All right, good afternoon, everybody. My name is Ari Rothman. I am a partner here at Venable in our ad law group, practicing out of our Los Angeles and Washington, D.C. offices. I'm joined by my partner, Ellen Burge, and my colleague, Shaheen Rothermel, and we're going to walk you through the various evolving requirements and trends for automatic renewal programs, which are a very hot topic right now. So in terms of our agenda, we'll give you some background and terminology that we're going to use throughout the presentation. Most of you are already probably familiar with that. The relevant laws, rules, regulations, the requirements, and how the various regulators are enforcing them today, so we know what the hot button issues are. So here are the types of subscription-based offers that we're seeing in the field that are being targeted. One we refer to, and the field refers to it as a negative option. That's where the customer's silence or non-action or failure to take an affirmative step to reject goods or services or to cancel an agreement, that's interpreted by the seller as acceptance of the offer. So stated colloquially, that's if a customer doesn't do something, then that is viewed by the merchant or the seller as acceptance to terms. That could be subscription programs, automatic renewal programs, membership clubs, continuity programs, and trial offers. Those could also be different kinds of subscriptions, but depending on how the terms and program is presented to the consumer, it could be viewed as a negative option because the consumers didn't take a step to opt out of whatever the program was that was being offered. And then, so who is looking at these negative offers? Obviously the consumers, because that's how the merchants and the companies selling the products and services are selling the goods. Law enforcement and quasi-enforcement entities, that could include, for example, the Better Business Bureau, which has a very close relationship with the Federal Trade Commission and state attorney generals. Class action attorneys looking for claims to bring, and then they go find plaintiffs unless they already have one. And your competitors to see how you're doing and you know what you're doing right and what they might view as doing something wrong or not as competitive, and they make changes based on what you're doing. So you've got a lot of different categories of people who are viewing these offers. So there's some overarching principles here that I'm more on the litigation side than I am anything else. But the things that I see are overarching principles: disclose the charges. What is being charged when you're charging the consumer, and for what? And it should be disclosed before obtaining payment information. And we'll get into the specific requirements later in the presentation, but send a confirmation after the transaction is complete. What you want to be in a position to do if you're ever challenged, whether you're in court or out of court, even if it's just a consumer complaint, is pull out as quickly as you can what you presented to the consumer, when you presented it to the consumer, and point to the clear and conspicuous disclosures surrounding the pricing, subscription terms, and everything else that might be important. That will go a long way in resolving the issue that you have or the complaint that you have, even if there are other technical violations, because there are a lot of ways to get tripped up given all of the requirements that we're going to go through. But do this, make your job easy, make my job easy, make everybody's job easy. Just pull it out, show them the consent to the terms, the clear and conspicuous disclosures, and that will go a long way in minimizing risk and resolving any complaints that arise. There's also the make it easy to cancel piece. So now on the applicable laws, rules, and regulations, I'll turn it over.
Okay. Hey everybody, I'm Ellen Burge. I'm going to take you through some of the sort of the framework of what we look at when we're putting together compliance essentially for these types of offers. So we've got a mix of federal law and state law, as we often do. Federal law is organized into different rules that apply to different types of marketing, different channels of marketing. So if you're online, you're thinking about ROSCA. the Restore Online Shoppers Confidence Act. If you've got something over the telephone, we've got the telemarketing sales rule, which has its disclosure requirements and things like that. If you're taking debit cards, you're paying attention to the Electronic Funds Transfer Act, which also has some disclosure and consent and authorization requirements. There's a very niche rule right now for pre-notification negative option plans. We're going to cover those briefly in a second, but those are things where you're actually sending advance notice of a selection and giving somebody the opportunity to accept or reject it before you send it, think old Book of the Month clubs. And then if there is a gap, if we don't have a very specific rule to sort of govern the mode or mechanism for making the offer, of course, there is Section 5 of the Federal Trade Commission Act, which simply prohibits unfair and deceptive marketing practices. So that can be used as a catch-all. On the state side, states also have what we always like to say mini FTC acts, but their own unfair and deceptive practices, prohibitions that they could use. There are several states now that have very specific automatic renewal provisions, really targeted towards governing these types of subscription programs and automatic renewal programs, and those are increasing by the year. We're constantly looking at new ones, so we're going to go over some of those. And there are some unique things in the states. More states are having, for example, notification laws, renewal notices and reminders and things like that. So we can go to the next slide and get into a little bit more quick detail on these. ROSCA, interestingly, it's there in 3 seemingly simple requirements, but of course the devil is always in the details. But the 3 requirements we have are to provide clear and conspicuous disclosures of all of the material terms and conditions of the offer. So what are you buying? How much is it going to cost? How frequently is it going to come to you? How often are you going to charge the card? When does somebody have to cancel? How do they cancel? There's a lot that goes in the disclosures, but the requirement there is to make the disclosures. And then, of course, obtain express informed consent. The informed consent piece comes because you've informed somebody of the disclosures of the material terms, and they have to provide explicit or express consent to the offer, consent to have you charge their card over and over again until they cancel. And then, of course, the third one, providing a simple mechanism to cancel. And, that the simple mechanism, it sounds like a simple requirement, but there's actually can be quite a bit to it. And we'll go get into that a little bit later with some of our examples. This is the negative option rule that I mentioned. This is the pre-notification negative option rule. This doesn't cover your typical sort of subscriptions and automatic renewal clubs and things like that. There was, within the last couple of years, sort of a proposal or a rule review sent out by the Federal Trade Commission to ask industry if maybe they should update this rule, maybe expand it, do something more specific with it, perhaps expand it to cover more of the types of subscription programs that we're talking about. So we'll have to wait and see what might happen there. Of course, as you can imagine, industry didn't think that would be necessary, as there is already such a framework to govern these offers. You can go to the next slide. The telemarketing sales rule, again, if you're on the phone, there's rules here. They're not inconsistent with notice, with disclosure requirements, consent requirements, things like that. But these are specifically written into the telemarketing sales rule, and there's specific requirements on making truthful disclosures about what you're selling, the fact that there's going to be a recurring charge to the account unless you cancel, again, when you're going to charge or the dates that they'll be charged, and how to cancel or how to avoid those further charges. So, so things to know there for the phone. We can keep going. We mentioned EFTA a little bit. Again, this is going to apply whenever somebody is using a debit card. We've talked about this actually for years and years, but these very similar requirements, it's disclosure requirements, it's getting an authorization, that somebody understands that you're actually going to be taking money from their account. That's what debit cards do. They're going to withdraw the money from a checking account. So a little bit more protection there has been in place for a while. Because, taking the taking $39.99 a month, that might actually put somebody into overdraw. So we've got issues there to think about with debit cards. And then, of course, as I mentioned, whenever you're don't have, if there is inadequate coverage on ROSCA, and in fact, often we'll see allegations of both ROSCA violations and Section 5 violations going hand in hand together. But, Section 5 is there, again, prohibits deceptive and unfair marketing practices. We've seen the FTC sort of outline facts that kind of create a Section 5 violation with an automatic renewal offer, and that again would be failure to make a disclosure of material terms, or the disclosures aren't clear and conspicuous enough, not getting proper consent for the offer, and making it difficult for folks to cancel. So, and then that's disclosures and such may be a little bit more on the deception side, but it could also be alleged to be unfair if you're billing people when they haven't given consent and they really haven't had an opportunity to avoid those charges. Okay, state law requirements. So as I mentioned, states, there's several of them now. We will frequently speak of California because it seems to be the leading standard. It's where we see a lot of cases. There are other states now with laws like California's. So often we are kind of bundling up all the state law requirements into a sort of a state standard. But of course, there are disclosure requirements. They're very much, it's the same type of stuff. How frequently are you charging somebody? How much are you charging? What are they getting? When do they have to cancel by? Those types of issues. Some of the state laws have a more pronounced definition of what is clear and conspicuous, and we'll look to that. This can all be very subjective, by the way, and we'll get to some of that in the cases later, but here's a little bit of guidance. Putting your disclosures in a larger font, or contrasting font color, or putting a box around it, or separating it from other text and putting it in a certain spot, sort of that visual proximity close to where you're asking for consent to have all the disclosures, and all of these things really matter. So we're often making judgment calls and doing our best to see how cases are playing out to see if they're fitting these clear and conspicuous standards, but it is, again, a bit subjective. There's sometimes there are other requirements for providing consent. They go a little bit further than just saying, explicit consent, and we're often talking about, do you need to have a checkbox or not, or can you just have a clearly labeled button that somebody is submitting their offer and agreeing to terms, or what can you do there? A lot of states have notice requirements, or renewal reminders, we should say. A lot of the times those kick in, especially when the length of time between automatic renewal, the duration of a renewal period is a year, sometimes 6 months, but usually a year. I think when you have something that's month to month, it's at least, a constant reminder. It's something that people know. But whenever you go out longer and you're dealing with something that's going to renew only annually, the renewal reminders really tend to kick in there. And some states have, certain time periods by when you have to send the renewal reminders and get back sort of if somebody's going to cancel, how you set that all up on those annual subscriptions. Cancellation requirements are often covered in the state laws, or we'll talk about California. California's got one that says that if somebody actually enrolls in your offer online, they have to be able to also cancel online. And that goes further than what we see under ROSCA or in the rules that the FTC is enforcing. And then there's sometimes special requirements if there's a trial period, a free trial period involved. There's a law in DC now that if your offer starts with a free trial period, you actually have to send notice before the monthly periods start and get somebody to consent again before the end of that free trial period to agree to go on the month-to-month paid subscription part. So lots of enforcement in this area. We see, as Ari had said, a lot of litigation issues federal and state regulatory, federal law enforcement actions, I should say, and the class actions. So, all right, next up. Shaheen, I think this is you.
Sure. So here's a list of the general requirements that Ellen and Ari have really already gone through. And we're going to go through these one by one and talk about the specific requirements under each of these. So the first is the disclosures. What do you need to disclose to people? And there's both, as Ellen and Ari said, the subjective side of this and also this objective technical requirements. So for example, here, you have to disclose that the subscription will continue until canceled, the price and features of it. So what are people getting? How much are they paying for it? The amount of the recurring charges, the length of the subscription term. There's a minimum purchase obligation in order to enroll in that. And then a description of the cancellation policy that applies to the offer, including the deadline by which to cancel. So disclosures need to be made, generally speaking, in a clear and conspicuous manner before obtaining the consumer's billing information. It needs to be in a visual or temporal proximity to the request for consent to the offer. So if it's online, in close proximity to where the person actually agrees and enrolls. There's a specific requirement under California law in particular, which is that the disclosure needs to be in larger type than the surrounding text or in contrasting font, type, or color to the surrounding text of the same size or set off by symbols and other marks. And this goes to what Ari mentioned here about what would a reasonable consumer, do reasonable consumers understand what they're getting, how much they're paying, all of the material terms of the offer, but not only that, but these technical requirements have been an area of challenge by plaintiffs and by federal and state regulators. So keeping in mind that these seem very technical, and even something that might look reasonable to you and might look commonsensical might still be challenged. So we always try to use our best judgment in understanding what reasonable consumers understand, but also making sure that we abide by these technical requirements as well. As Ellen mentioned, there are program-specific disclosure requirements for certain types of products. So Vermont in particular, which applies to annual renewal programs, you have to clearly and conspicuously disclose the terms. It needs to be in bold-face type, and we've seen actual challenges come out of this as a result of this. For trial offers, as Ellen mentioned, that DC law, you have to provide additional disclosures as well as under California law. So when the trial is going to end, that the pricing is going to change once the trial ends, the price that will be charged after the trial ends, the cancellation deadline, and oftentimes there needs to be a hyperlink to the cancellation mechanism. So the next thing that you need to do after you disclose is obtain affirmative express informed consent, and this is a conglomeration of the nomenclature required by federal and state law, but generally what that means is that it has to be an affirmative action. The consumer has to clearly, explicitly indicate that they understand, unambiguously articulate their consent. Silence should not be interpreted to be consent. Just because somebody doesn't do something doesn't mean that they're consenting to it. Informed consent means that they have to receive all the disclosures. So if they're not, a consent cannot be informed if they don't know what they're agreeing to. As I mentioned, that it needs to be an affirmative action opting into the automatic renewal provision. We're seeing a lot of activity by regulators on the federal and state level who say that consent needs to be obtained through a distinct method, such as an unchecked checkbox, a signature, or similar method that the consumer must affirmatively select to accept the terms and no other portion of the offer. That means an independent checkbox is normally what we hear in our conversations with these regulators, is that you need to have a separate checkbox. That checkbox needs to be immediately adjacent to the terms of the offer. So you have a checkbox and then you provide the disclosures. And that those terms need to be presented on the page itself, not via a hyperlink. And that those disclosures and checkbox should not be muddled with other disclosures. And what I will say too is we're seeing this in federal, and we'll talk about this later, we're seeing this in federal and state regulator consent decrees. We're seeing it when we're talking to these regulators and trying to negotiate consent decrees. We see it in court filings with regulators. And what we are more and more seeing, particularly in California plaintiffs, is that now they're adopting that and saying that that is the law, even though it is in a consent decree a settlement, a one-on-one settlement between a company and a regulator, rather than an adjudicated court decision. So additional consent that is required in program-specific offers is for a free trial with a term of 1 month or more, where it'll automatically renew at the end of the period. The seller needs to notify the consumer that it's going to automatically renew, and notwithstanding their consent to the trial, obtaining that additional consent. And again, that consent needs to be obtained even if the company already obtained the consumer's affirmative consent to the free trial. There's card brand rules now that explicitly address consent in the trial context. Now, in the annual context of annual programs, Vermont law says that in addition to accepting the contract, the consumer has to take an affirmative action to actually opt into the automatic renewal provision. And so I think what we're seeing there is this idea of that separate consent that's in addition, that's explicit on its own standalone consent to the automatic renewal offer.
Okay, then I think I'm picking up here with order confirmations. Go to the next slide. So again, order confirmation, this is really here, this is much more of an amalgamation of California and similar state law requirements than federal, but we do think that this is bleeding over, and I'll explain that in a second. But California does require that you send a written order confirmation, repeating the offer disclosures essentially. So reminding the customer everything that they've agreed to. And it has to be, it's an order confirmation. California calls it an acknowledgement, but it's got to be something that, and the quote here comes from the law, but in a manner capable of being retained by the consumer. So an email, you could probably try other things if you're shipping actual product, maybe sticking something in the box, but you got to make sure it's something that the consumer is not going to just kind of throw away and not look at. They have to, be able to keep it and retain it and refer to it really whenever they want to cancel and know where they're what they're doing and understand how much they're going to be charged in the future. So and then again here, if there's a free trial period, specifically telling somebody that you've got to cancel within this free trial period or else you will be charged is a really important requirement that is emphasized in some of the state laws. And we talk about state laws, I'll just mention this really quickly. If we talk about something like a California law or Virginia law or New York law, those laws are written to protect their residents. They tend to be followed sort of on a national basis, especially when you have something like California, because it's so impactful. It's such a huge state. And now the California law looks a lot like what the law is in Virginia and New York and maybe some other places to come. So it grows into a sort of a national standard. I suppose it's possible to be very strict in your compliance in a way if you only want to comply with California law with California consumers. But I think in this day and age, it's really difficult to know where anybody is. I don't know how easy it is to tell where they may be. I don't know, Ari or Shaheen, if you faced any of these issues in any cases that you've had. But, I know a lot of that our clients would just sort of follow this across the board.
Yeah, and I was going to add on to that, Ellen, that we've seen, I think, in at least one case brought by an AG where they pointed out that a company only gave certain notices to residents in certain states. And so I think that regulators are looking to that as some sort of indication that their practices in other states might not necessarily be adequate.
Mm-hmm.
And under certain circumstances, the card brands required it anyway. So there's no reason not to do this. And if you're not doing it, it could, you might have to answer the question someday why you didn't. And especially if you did it for some states and not others, that might raise a flag, because then it's a requirement, at least for some states. And even if it's not required in others, it's prudent to do that. It'll make responding to any challenge a lot easier, even if it's not technically required.
All right, well, anything else, Ari?
No.
Okay, let's pick back up on our summary of requirements on the next slide. So taking you next to the simple cancellation mechanism. Again, the ROSCA requirement is to provide a simple cancellation mechanism. And that sounds easy enough in theory, but what does that really mean? Is a 1-800 number might be simple, but what about a 1-800 number where you're on hold for a long time, or where you have to leave a message and get a call back, or you call in and you want to cancel, and there are several attempts to save your sale or to try to downsell you into something else. So all sorts of questions about really what is and what is not simple. Generally a toll-free telephone number should work out okay. It's a cost-free mechanism. But again, how you play that out can really matter. Sending an email might be okay too, but if you have people checking that email inbox frequently enough, are you allowing people to cancel by mail? Are you getting your mail and checking it? So these all might be fine. They're simple enough, but how you execute on it can really matter. We mentioned earlier, I'll mention it again, that the third bullet here, that in California, consumers who accept the automatic renewal offer online must also be allowed to cancel online. And what does that mean there? Does it mean, it's an easy link in your order confirmation email? Are you giving them sort of a link that goes straight to a form where they can click a box to cancel, or is it a link to like the main homepage of the website and they're stuck sort of finding how to log into their account, and then from there where to go to find a cancellation? Chat might also be a chat feature cancellation might also be an interesting discussion too, if you're looking at that, because what if your chat is not available 24/7, or the chat person gets you into all sorts of downsells and sale saving and all those types of things too. So again, lots of things to think about here. I think we can go to the next slide. We're now on renewal reminders in our progression of sort of compliance requirements. This is, again, it's a best practice if you can do it. And I've seen to get them more frequently, I think, even on something that I might go month to month on. I know I have bought things before, and I'll get a renewal reminder that my next shipment is coming soon. If I want to cancel, go here. So I think it's becoming a more prevalent best practice in the industry, but it's certainly a required practice in some state laws. Again, I mentioned that more often whenever that term of the renewal is 12 months or more, again, people forget. We've got a couple more state nuances here. North Dakota imposing a renewal notice requirement for automatic renewal periods that are longer than 6 months. And in North Dakota, actually, you can't have renewal periods of greater than 12 months. So there's, again, more quirks there. The notice sometimes, depending on state law, might need to include certain disclosures. So you're going to have to check that out. The timing of the notice could vary. Sometimes the law is very specific about how far out you have to give notice. You're going to want to think about how frequently do you want to give notice. Do you want to try twice? Give people a second chance to see it. And what do you have to put into it? So, and then again, that's the same concept of making sure you're sending this notice in a way that people can find it easily enough, go back and search their emails and find it and keep it and reference it. And then I think we're going to move on to the next zone, and I think this is you, Ari.
Yes, material changes to the offer. So now we're talking about changes and how those are communicated and when. So if there is a change after the transaction is finished, then you have to provide current customers with clear, conspicuous notice of the change, and at the same time, give them the option to cancel and a mechanism to do that. So for instance, a hyperlink to allow them to do that, because it's essentially, from the regulator's perspective, a brand new offer. If a company charges a consumer a different amount, so you're changing the price, then that needs to have a written notice with specific disclosures and the best practices to obtain consent. So there's notice, there's sending them an email, for example, that has the changes. But if you really wanted to button it down to prove that the changes were received by the consumer and acknowledged by the consumer, you could have a checkbox or some sort of call to action that forces the consumer to acknowledge those changes before you actually implement and charge the consumer more money, for example, or change the shipping frequency or the product offering or whatever the change is. It's the next one, Shaheen.
Actually, hey, Ari, let's give that code. I think we need to give it.
Oh, yeah, okay. I didn't realize we were there already. All right, so we're halfway through. For those of you looking for the CLE code, it is Renewal 2021. So Renewal 2021. I'll also take this opportunity to note that we've received a lot of questions, way more than we will have time to answer. I think we either answered some of them already through the slides, or we're going to answer the rest of them. We'll find a way to deal with them. A question, I'll just answer two of them really fast that I've seen with some frequency. The first is can a business be considered a consumer? The answer to that is yes. The assumption should be, if you're doing business in all 50 states, that a business is a consumer. That's the short answer there. Another question we have is does it actually have to be these notices we're talking about? Does written mean mailed or put in FedEx or something? The answer to that is no. For example, a post-transaction receipt can be sent by email, but it has to be sent in a form. Again, these are general broad stroke answers. Sent in a form that is retainable by the consumer. So not, for example, on something like Telegram. Not that that would be feasible anyway, but I'm just using that to prove the point. The next, so again, keep the questions coming in. We'll do our best, but we've got a lot of them. And thank you for sending them, and thank you for joining. We've got almost 300 people online right now. So let's move on now to state law updates in California. Shaheen, do you want to take that over?
Sure. So California, if you'll recall, a couple of years ago tried to pass a law that would tighten its restrictions on certain types of programs, trial programs, and that didn't really gain any traction. But it looks like there's being a resurgence in that because this new bill has been introduced. And the bill would provide, if passed, it would provide that for free gifts or trial or promotional discounted price periods, so discounted price that converts into a paid subscription with an automatic renewal. If a company does that they would be required to provide a notice at least 3 days before, but at most 7 days before the expiration of the trial or the discounted price period, a notice with explaining how to cancel. And if that notice is sent electronically, providing a link that directs consumers to the cancellation process. The question of also tightening this idea of allowing people an easy or a simple cancellation mechanism. What the law would do is that a business that allows a consumer to accept the automatic renewal offer and enroll online, that business must be required to allow a consumer to terminate online, as Alan already pointed out. But the law now would say that it has to be at will and without engaging any further steps that impact or restrict the consumer's ability to terminate the service immediately. And the bill would specify that the cancellation method must either be on an internet website in the form of a direct link or button to cancel, or in a termination email formatted and provided by the business so the consumer can send to the business without additional information. And right now there's a hearing scheduled in April, so we're keeping an eye on that, seeing if this one gains some traction, because that will probably affect how a lot of our clients and a lot of companies in the industry will handle trial programs and cancellation. But there have been a couple of other states that have had updates as well.
All right, so and we've touched on a lot of these, so I'll go over them super quickly. But New York has a new law that went into effect in February 1st, I believe. It's really close, maybe even almost, maybe exact, to the California's current automatic renewal law. So I guess on the one hand, there's some familiarity there, and it's easy is relative, but easy enough to understand what the requirements are and maybe to comply with. We mentioned Vermont. We've started to see some proposed claims in that space, again, with their 1 year longer periods, bolding the disclosures, providing renewal notices, things like that. There's an interpretation that Vermont law actually requires a second opt-in, or I shouldn't say second, a standalone opt-in just for agreeing to the automatic renewal terms, which would be separate and apart from just saying, for example, you agree to the terms and conditions or a privacy policy or other things like that. So that's an issue that we've sort of had some debates on and looked at a little bit. And then we mentioned it in DC to obtain, again, consent before the end of a free trial period that has a renewal term of a month or more. So we don't need to belabor these points, but the one thing that I think we'll be watching for is the private litigation that will come out of these types of things. I believe DC has a private right of action. Vermont may as well, based on what we're seeing. I'm not so sure if New York has a very explicit private right of action, but much like in California, the lawyers tend to find ways to bring the private cases. I don't know if Ari or Shaheen, you want to comment on that briefly, actually, how our cases brought under California law, because California law doesn't exactly have a private right of action, I don't believe, but there's sort of a backdoor into it, and I think that's what we'll see potentially in New York.
Well, the DAs are active, so we're seeing that, and theoretically, the CLRA could be used. The California Legal Remedies Act could probably be used for something like this, just like it could be used to bring cases against under the Sherman Law, which is a state law equivalent of the Food, Drug, and Cosmetic Act. So that, or it could just be brought up as a 17,200 or 17,500 claim, straight up deceptive trade practice claim as well. And then the argument would be that because the California legislature has said that these things are required if you don't do these things, and therefore it's deceptive, and so therefore it violates the broad California laws governing consumer deception. And you don't want to deal with the district attorney's offices anyway. So that's how that's how that's going to go down.
All right, well, let's keep moving. I think Ari, you're going to talk next. We're going to start talking about enforcement actions, and Ari's going to talk about money and redress. Right.
So this goes back to the FTC brings these cases, and the DA to some degree, although the DAs don't bring cases under the FTC Act unless the FTC is also involved. But here are the bottom line remedies: injunctive relief. So an order requiring the company to do or not do something, and that at a bare minimum will require the companies to follow the existing laws. And because the government is targeting your business at that point, government will likely demand some specific provisions that are particular to the situation that the government identified. You might not find those exact words in the statute or in the regulation, but the argument is going to be that whatever it is that the government is requesting is needed to resolve a particular problem that the government has identified. Currently, the FTC under Section 13B is coming in looking in for refunds, disgorgement of profits. There's some penalties that are involved. You can see the statutory penalties there too. The phrase rescission of contracts, that's just a fancy way of saying they're canceling the agreements that are in place. So if they've got a bunch of subscription agreements, all those will get canceled and undone through refunds. And then we made an important note here, because I'm sure some of you are watching this. The Supreme Court is currently deciding a case called AMG Capital, in which it's going to decide under a specific provision of the FTC Act whether the government can obtain restitution, so money under the FTC Act under 13B. There are other ways that the FTC can get money that are independent of 13B and that will not rely on AMG Capital. So AMG Capital, the takeaway there is it is focused on a specific provision of the FTC Act, not the entirety of the FTC Act. And if AMG is reversed in favor of the businesses, that doesn't mean that the government cannot go in and seek money under different provisions of the FTC Act, including for ROSCA violations, which would come under through Section 19. So that's what's happening. Basically, money in orders to change your practices. That's how you can sum this up.
Yes, so in terms of what are some recent areas of enforcement on the federal level of the Restore Online Shoppers Confidence Act, these are broad strokes what we're seeing. Claims that the marketer did not disclose the terms of the automatic renewal offer adequately, so not clearly and conspicuously, that they did not adequately disclose how to stop recurring charges. And one thing that we're seeing a lot of is the failure to disclose the cancellation deadline, so that a consumer needs to cancel a certain period of time before that next charge in order for their cancellation to be honored and effective. And the business did not provide a simple cancellation mechanism. To Ellen's point earlier, the company, for example, tried to save the sales, it tried to downsell people, it didn't honor people's requests after they were made. And so we're seeing that a lot. Some more specific trends that we're seeing, the failure to disclose the total cost and frequency of the charge. One of the issues is that there's, for example, multi-month subscription periods, or where the frequency is not exactly clear, or the frequency of specific charges are not clear. Maybe there's a discounted period for a certain time, and then you roll into another charge. And so the failure to really explain that, the failure to explain when the charges will hit the card. So if it's going to be charged in a lump sum at the beginning of a 3-month period, or at the beginning of a 6-month period, as opposed to every month throughout the 3-month or 6-month period, sometimes people were confused about that, according to the FTC. What we're really seeing a lot of from the FTC, I think, is the cancellation mechanism, the inability of consumers to cancel. That's been a big trend that we're seeing. So a couple of allegations in recent cases is that subscribers who wanted to cancel their subscription could only do so by an undisclosed cancellation deadline. So they thought they were canceling, for example, before that month ended, and then the company said, well, no, you're too late. We're going to have to hit their charge. You're going to be charged for this month, but we'll cancel it next month. People called a customer service line, and the customer service line was inadequately staffed. People had to wait on hold for 30 minutes. People just got disconnected from the lines. The customer service reps engaged in really allegedly aggressive tactics. So one thing that companies should note based upon this trend, and Ellen and Ari will go more specifically into the specific cases, but one thing to note is that you should look at the cancellation mechanism clearly, and not only are we offering an online mechanism, are we offering a telephonic mechanism that's open for business hours, but actually look at what your call reps are doing, look at the scripts, analyze what's really happening. Are you getting complaints, for example, about the inability to cancel? Is your BBB profile starting to see those complaints creep up? You should really keep your finger on the pulse with those, because that is something that the FTC is looking at right now. And I think I'll let Ellen talk about some specific cases and specific examples.
Okay, so the first one we have for you is the FTC case against ABC Mouse. I think this is children's learning software, if I'm guessing by the name correctly. But anyway, so here, actually, if you look at the picture, this came from some of the FTC papers that were filed in the case. But the FTC, this is a case where consumers are signing up. It looks like you're paying $60 for 12 months, and it looks like you can split your payments up into some easier installment payments. And what the FTC alleged was that it wasn't clear that after the first 12 months, this was going to automatically renew. And there is a checkbox here that says I agree to terms and conditions down on the right side, and if you were to click that link, you would read some terms and conditions about the renewal. And the allegations here is that burying them in the hyperlink, that was not clear enough. There were also potentially problems with the claim that there's easy cancellation because it was hard for people to find a phone number or an email address or something like that to cancel. So we'll go to the next slide and just real quickly talk about the settlement agreement here. As most FTC settlements go, there are, again, the injunctive provisions requiring, or prohibiting, really, I should say here, misrepresenting that something is free or is, has no obligation or won't renew unless those terms and conditions are disclosed, and unless you tell the the customer that they're going to have to take some action to avoid the renewal and avoid further charges, and make clear disclosures about the cost and what they're going to be paying. And there again, the last one, the deadline by when you have to cancel to avoid the charges. So moving on, more in the injunctive relief here, obtaining consent through a checkbox. So again, whereas ROSCA itself does not say, what Congress has put in ROSCA, it does not say you must use a checkbox. We see it come out here in an FTC order. FTC orders often become a governing standard of sorts. So this is an example of voicing a strong preference for a checkbox or something that the consumer can do to affirmatively express their agreement. And then here, the simple cancellation mechanism, mirroring here a little bit of the California law requirement, which ROSCA doesn't have, but here saying if somebody enrolls online, they have to be allowed to cancel online is sort of the highlight here. Just a note on the money that we saw a $10 million monetary relief remedy there. Okay, and then there's an ongoing lawsuit, another example, ROSCA lawsuit that the FTC has filed against Match, the Match Group, which obviously has Match.com. There are a lot of different allegations in this complaint. There are some allegations about exposing consumers to sort of fraudulent messaging, or some promises about if you don't find a match within 6 months, we'll extend your subscription period longer at no cost. But the big issue here that came up under ROSCA was not providing that simple mechanism to cancel, because whenever the customers were going on to cancel, there were multiple save attempts. Cancellation was hard to find. It was hard to navigate. They had a hard time understanding what to check. And in some cases, I guess some people thought they were canceling and they ended up renewing. I did catch one question that came across, and somebody asked, well, does this mean that we can't ever try to save the sale? And the law doesn't say that, but I think you have to really pay attention to what your save efforts are looking like. If the save attempt is reasonable, if you're not pushing too hard, if it's not too expensive, if the save attempt doesn't otherwise sort of water down the ease of canceling, then maybe you can do it. But it's certainly something to look at there. And here in the Match.com case, it seemed to be too much. And that's ongoing litigation. Of course, no decisions have been made there yet. I think we're going into state enforcement. Okay, so I think this one is me too. So again, we've mentioned the California Automatic Renewals Task Force. We're gonna go over a couple of these cases in just a second. There's cases now. We've seen a case now in DC against Town Sports. That's they own Washington Sports Club, for those of you who are in the area and know that. That case has allegations about failure to disclose, failure to give notice about the renewals on renewing memberships. There's another case we've been watching in Massachusetts that the Massachusetts Attorney General filed against Safe Home Security. This case, the interesting point here is that Massachusetts does not have one of these automatic renewal laws that it brought this case under. It actually brought it under its general sort of consumer protection, unfair and deceptive practices type of a thing. But there again, a lot of the same thing, difficult to understand the disclosures, have consumers having a hard time canceling, those types of things. And then I think, I don't know if one of you is going to cover Adore Me, but that's another case that we've got. So again, a lot that we're following. We should probably keep moving through in the interest of time. And then this is actually, so I should mention here, we won't go through all of this, but notwithstanding the FTC lawsuit against Match.com, California has also filed a lawsuit more recently against Match.com. It's the highlight here is that the California suit is actually going far beyond sort of where the FTC is focused in their case. The FTC was focused again on sort of that cancellation challenges and needs of cancellation. And here we've got all sorts of allegations with problems about the disclosures and whether they were complete and thorough, clear and conspicuous, whether the placement was okay, whether the font was too big or too small. So again, this one's interesting because it's really getting into some of those subjective components that we talked about early on, and we'll have to see how this shakes out. And I think we can probably skip over to a classmate's case.
And then we've got Home Chef. That is another state of California case. This is a DA example. It's not only the district attorney, not only Los Angeles, but also San Diego and Santa Cruz. And there were, again, these what are now becoming pretty standard violations of California law in terms of what these cases are bringing. Failure to clearly conspicuous disclose the automatic renewal terms. That's the first place they go. Then once there's a failure to disclose, there is therefore a failure to obtain affirmative, express, informed consent. Now you could have your clear and conspicuous disclosures, but if you don't have the right call to action, or if it's not placed in the right, you don't have the right call to action or proof of the right consent, then you still need to follow the second step. And so that's why we've separated those two out. The third one is post-transaction, failure to provide post-payment acknowledgement that clearly conspicuously disclosed automatic renewal terms. That's, for example, the confirmation email, also required under certain circumstances by, for example, the MasterCard rules and ROSCA, or at least EFTA, sorry. And then failure to provide simple mechanism for consumers to stop recurring the charges. That's something that should be there too. Now the settlement numbers, those aren't staggering. Up to $250,000 restitution, $150,000 civil penalties and costs, and $50,000 to a claims administrator. But it's all relative. I wouldn't take away from this that this is sort of a benchmark for the California DAs or any other regulator in terms of what the price of a settlement will cost. It'll depend on what happens. And then in the actual consent order, the key provision there is under the disclosures. We've bolded and underlined that. The automatic renewal offer terms must include the words automatically renewing subscription. And that's not a technical requirement. I mean, if you go to the statute, you're not going to see those words in the statute. But this is an example of the DAs taking the law that existed and fashioning a remedy that is specific to the situation they had. And this bold and underlined language, it's not inconsistent with the statute. At least that's what their position would be. It's consistent with the statute. So this just gives you an idea that if you get tangled up in one of these disputes, you can look for ways that the government will negotiate provisions that might be viewed as outside of the statute, but in fact are consistent with it. And then we'll send the slides out afterwards so you can see that. Private class action trends, I'll shoot it over to Shaheen.
Sure. So we're seeing a lot of private class actions that are follow-ons to these regulatory requirements that Ari and Ellen talked about that are really above and beyond the statutory language of the laws. So this idea that people are companies that are failing to obtain affirmative consent via a standalone checkbox or similar mechanism, we're seeing class action plaintiffs actually cite to the consent decrees to say that is the law. Under the Vermont law, some class action attorneys are saying that in addition to accepting the contract, the consumer must take an affirmative action to opt into the auto renewal provision, and actually imposing sort of technical requirements under this statutory language of a standalone checkbox. Failing to adequately disclose a cancellation policy. Again, that cancellation deadline, I can't impart upon people how often I see challenges under that. Be careful when you say cancel anytime, because we're seeing that be a challenge, that when you say cancel anytime, but you have to cancel before a certain time in order for it to be effective, that's misleading, and therefore you did not adequately disclose the cancellation mechanism. And the failure to adequately disclose trial terms. We're still seeing a tranche of cases against trial offers. Here are a couple of examples, and I welcome Ellen and Ari's thoughts about this, but here's one example that was against Bed Bath & Beyond. The plaintiff challenged their Beyond Plus membership program that would give people a discount on their future programs if they paid this membership fee. The biggest issue that I thought was important to highlight here is this failure to obtain affirmative consent. So you can see in the filings, you have the terms and conditions, and you see I accept the terms and conditions of the program with a checkbox. And this is a little bit like the ABC Mouse case that Ellen talked about a bit ago. And what the court said is that the auto renewal terms must actually be in visual proximity to that request for the consent. The terms themselves, not the access point to the terms, need to be in visual proximity. And because the required terms did not appear on the web page containing the request for consent, this was inadequate. And the defendant made the argument that this is normal. We use hyperlinks all the time. The court said, I don't care if that's normal in online contracting and normally accepting terms and conditions of a website. That's not enough here. But one of the wrinkles in this one is that the plaintiff failed to adequately allege that the technical violation to this violation caused injury. And that's a defense that we're seeing being used more and more frequently, and it's gained some traction. Ari, I don't know if we really have time to talk about it, but there was a California appellate court decision last year that gave this argument that a plaintiff needs to allege causation, that this technical violation actually resulted in economic injury. And then we have one more slide here, and this is an example of a case where the court, I think, just got it wrong. But what happened here is that the plaintiff alleged that this disclosure wasn't clear and conspicuous because it was presented in a smaller font size and the surrounding text, failed to state that the subscription would continue until canceled, failed to describe the cancellation policy, and failed to state the amount of the recurring charges. The court let this case proceed on those allegations, and you can see here that there's a pretty robust disclosure, and it's even got continuous service program with an asterisk and bolded. But again, there's these technical arguments that the plaintiffs are making that this isn't large enough, that there's specific aspects of the renewal program like the cancellation mechanism and the length of the renewal term just wasn't here. And I think that there are defenses that could be made in this case on this one, but this is an example of plaintiffs making outlandish allegations and courts accepting them.
Well, it looks like we've come to the end of the road. I'm sorry to keep everybody a minute or two behind, but a couple quick things. I believe our slides are going to be available. Am I speaking out of turn, or is that correct? Okay. Which would be great. And then as Ari said, we got a lot of questions. We'll try to do a summary or some, of the questions and answer what we can. Maybe we can do a follow-up article or something like that. But thank you for all that, and thank you everybody for attending.
And feel free to reach out as well. If we can help, we're here. Thank you all.